In Westchester, divorce attorney, with another episode of Lessons from the Divorce Wars. So this session is kind of an extended footnote from my last session. So to recap, last session I said attorneys should really avoid imposing their own values and beliefs on a client and twisting their arm and trying to convince them that they're wrong about what they want to settle for. Today's session is, yes, an attorney should avoid doing that, but it's also right and proper for an attorney to advise their client what a judge is likely to give them in the first place. So in other words, only an attorney is really going to know, as a general rule, as but one of many, many examples. Let's say there's a business that's getting valued. Only an attorney is going to know, okay, generally speaking, a judge is not likely to give 50% of the value of that business. Businesses are usually awarded on a much lower percentage than that. Certainly the court has discretion to award 0%, but usually those percentages come in somewhere around 10, 20, 30%, based on a wide variety of factors. An attorney is going to know, based on their knowledge of the law and experience, that the more likely that the non-titled spouse is able to show some kind of significant indirect efforts that allowed for the buildup of that business, as but one of many examples, a homemaker wife that took care of the kids while the husband went out and built up his business. Another example of direct efforts that would increase that percentage from, kind of more in the range of 10, 20% is where the wife stepped in and did direct efforts. I've had cases where the wife stepped in and did marketing and accounting work for the business to help build it up, helped with advertising, helped with bookkeeping efforts, et cetera, et cetera. All those would increase that percentage award from 10 to 20% to higher, maybe now you're talking 30, 40, closer to 50% distribution. So an attorney is going to know that, and they should advise their client, this is what I think a judge is likely to give, and this is therefore what my recommendation is in terms of a settlement, because of course a judge can go either way on it. Judges can award 50, 10, et cetera, et cetera. So give that advice, but also on the flip side, don't impose your morals and beliefs. If you give that advice to a client and the client says, I hear what you are advising, but this is what I want to do. This is my life. This is my finances. These are my kids. That's where you have to, as an attorney, draw the boundaries and say, okay, I've done my job. I've advised you accordingly. And you've made the decision as an adult as to how you want the case to end up. The client is always captain of the ship. They should always guide the attorney as to how they want to settle a case. Definitely an attorney is first mate on that ship and should tell the client, this is where I think the icebergs are. This is where I think, based on my knowledge of the law and my experience, this is where I think the ship should go, but that's where the advice has to end. And you have to allow the client to guide where that ship ultimately sails. So if you're looking for similar answers to questions like this, check out my blog. You'll find it at blivenlaw.net/blog. See you next time.